We bring this lecture to you each year because we continue to face mounting malpractice rates, and Georgia is listed among the nation's worst legal hellholes. This year, Georgia's Senate Bill 68 and Senate Bill 69 were signed into law in April of 2025. This represents a comprehensive overhaul of the state's civil justice system for the first time in 2 decades. Senate Bill 68 aims to curb litigation abuse and control insurance and legal costs, and Senate Bill 69 regulates third-party litigation financing and restricts funders from influencing case decisions or legal strategy. Together, these laws seek to reduce excessive lawsuits and enhance transparency and accountability in Georgia's courts. Bartley Miller is a partner at Sterling Seacrest Pritchard, specializing in insurance solutions with a focus on the healthcare industry. He earned a BA in Risk Management and Insurance from the University of Georgia, Terry College of Business, and was named partner in 2010. During his time at UGA, Bartley was a starting offensive lineman and a 3-year letterman, and he was named to the All-SEC football team. Let's give a warm welcome to Bartley Miller as he presents an update on Georgia medical malpractice environment.
All right, good morning. All right, everybody ready to go? This is always a fun topic for 7:30 in the morning. It is a pleasure to be with y'all. I don't know how many years this is. I believe we kind of came in with GOGS around 2015, 2016, and then I've been doing this talk for, I don't know, probably 5 years. So it's always fun to see some friendly faces and super grateful for our relationship with GOGS. There's a lot to talk about, and I'm going to try to hit some highlights, and many of you have heard a lot about what occurred with SB 68 and 69 this year. I will give you some talking points on that of what I think will have a material impact on both the insurance and the litigation environment here in Georgia. But then I'm also going to talk about some kind of current events and trends that we're seeing, which may open the door to more meaningful change that we're excited about. I'll talk about kind of what trends we see in the insurance market. One of y'all's biggest spends, if you're in private practice, is your malpractice insurance, outside of the benefits and payroll for your employees. So we'll talk about that and how that is going to impact you both now and in the years to come. I'm going to talk about some of the legal venues. As I said, I'll talk about tort reform, and then I'll tell you a little bit more in-depth overview of how the insurance market as a whole is responding. So before I go forward, for those that don't know me or know our firm, I am really an insurance agent. That's the best way to, or broker, that's the best way to describe us. So we work with, over 8,000 physicians. I spend probably 75 to 80% of my day in healthcare. That's all I do. I've been doing this 20 years now, but we advise on the placement of insurance, the brokerage or the leverage of the insurance market to your benefit, but then provide risk management and legal services as well with our in-house risk management, patient safety team, and also claims advocacy team. So that's the way we come at this. Let's talk about the Georgia market, and I'm going to run through some of this relatively quickly. So when we talk about judicial hellholes, we're one of the worst venues in the United States of America to be a physician, unfortunately. And that has really trended this way since 2016. Last year we were the number 4 ranked judicial hellhole in the country. I think a big part of that was solely because one of the big Ford cases got overturned in Georgia. I think we now have since seen another $1 billion award against Ford in Georgia. So I expect us to remain on this list and stay high on this list. The one thing, people ask me, does it actually even matter if we're named the number 1 judicial hellhole in the country? And the answer to that is no. But here's what it does. it puts attention on the state of Georgia, and we are seeing it with the traveling plaintiff attorney, right? So we are seeing two things. Number one, really good plaintiff attorneys that otherwise wouldn't be taking cases in Georgia come to Georgia and be co-counsel in cases and invest their time and energy in activity in the state of Georgia because they know that there's a high probability of big numbers in the state. Number two is they're investing a tremendous amount of money in legal advertising in the state of Georgia. You can see up in that upper right-hand corner, $65 million in legal advertisements invested in the first 2 quarters of '24. That's a tremendous amount of money. Well, that's going to create frequency and then ultimately lead to severity in the state of Georgia. So y'all have seen this chart before. This is National Practitioner Data Bank information. So this is the number of paid claims are your blue bars, and the red line there is the average paid indemnity. You can see that nationally, the number of paid claims, or what we refer to as frequency, has reduced pretty consistently since the last med-mal crisis back in 2001. However, we continue to see indemnity or average indemnity increase. In Georgia, we got a different story. So we saw, number one, frequency had declined since the early 2000s nationally. You look here since 2012, right, we've seen actually an increase in the number of paid claims in the country. And arguably, you know, back here in 2001 was some of the worst experience we've ever had in the country, and now we're reaching numbers that are getting back up there. And then arguably you see the $400,000 delta in the average paid indemnity. That is a tremendous difference. And you can see some of the volatility that's come with that in recent years. So in addition to the frequency and severity trends, one of the things that's often talked about in Georgia, and if you talk to the insurance executives of the insurers, what are they worried about? It's these crazy high verdicts that we're seeing out of Georgia. So this information is actually a little bit out of date. There's been a few additional cases on top of this, but if you look at this, since 2016, there's been 41 med-mal verdicts in the state of Georgia that have paid in excess or had awards in excess of $10 million, right? When you look at this list and you compare us with Illinois, Illinois, New York, Florida, and Pennsylvania, one thing you've got to consider is how much bigger those environments are than the state of Georgia, right? For us to be on this list is troubling. Further, we've had 30 of those 41 verdicts since 2021. So you can see it's escalated very quickly. And that's the next slide. You can see how much money this is in estimated value since 2021. It's just significant what the trend has been of late. I get the question all the time when I'm on the phone with my clients throughout the state of Georgia, especially from my South Georgia physicians and North Georgia physicians. They say, well, all this is just Metro Atlanta risk that's driving this activity. And the reality is it's not. Now, listen, Metro Atlanta and the Metro Atlanta counties are certainly driving a significant amount of the claim activity and the severity. But I think there's many that would argue, whether it's the defense bar or the insurers, that Bibb County, Macon now is the worst venue in the state of Georgia. And there's others, and I'll use the term smaller towns, that are trending in that direction as well. Further, we've seen some of the most conservative, historically conservative, legal venues in the state. Union County is an example, where we would be shocked to see a large verdict come out of that county, yet we have. So it is really happening throughout the state, and it's really hard to determine what you're going to get. So combined ratio, so the easiest measure for an insurance company is taking total claim expenses, what the expenses of the insurance company are, running underwriting, claims, patient safety, et cetera, and dividing that by the premium that they receive. If that ratio is over 100%, right, they're losing money theoretically, right? Now, what's not often talked about is they're making investment income on their assets too. But if that number really reaches kind of around 106, 107 plus, that means the insurance company is losing money on their underwriting operations. Right now in Georgia, we are probably seeing, combined ratios between 130 and 145% for many of these insurers. So that means for every dollar they take in premium, they're expecting to pay out $1.30 or $1.45. Compared to the national numbers, the average in the industry right now is about a 108, 109. So that tells you nationally we're seeing trends too, but Georgia is performing very poorly. So what does that mean? That means we've seen a lot of insurers pump the brakes in the state of Georgia. So we haven't seen anybody run from the state, which we've seen before. But we have seen many insurers that have had substantial books here for a long time really pump the brakes of, we've got to evaluate where we want risk and how much we want to continue to invest in Georgia. Well, that's not good for the consumer, right? We need competition in this state. The most important aspect of controlling cost outside of the tort reform things we're doing is making sure that we keep competition in this state. From a macro perspective, I think we're going to see some changes in the insurance industry as a whole. ProAssurance and the Doctors Company, two of the largest med-mal insurers in the country, are supposed to come together in this next year. Obviously, our GOGS is partnered with the Doctors Company, the largest physician med-mal insurer in the country. But we are seeing the market shrink some, right? And that can be concerning of making sure that we continue to have competition in the market. All right, let's talk about tort reform. So again, I'm going to hit this at a higher level, and I'm going to focus on the areas that I think are going to be most meaningful. So for those of you that don't know, in the state of Georgia, if you go to trial, well, used to be, when you went to trial, the jury would only hear what the gross medical charges were in a case, right? So in other words, the charge master number. So you go to the hospital, it's a $30,000 bill, right? The actual reimbursement's actually, $5,000. The jury never saw what the out-of-pocket expenses were for the plaintiff, never saw what the reimbursement was for the physician, the facility, et cetera. And so what did that do, right? It artificially inflated damages, right? Because the way the jury would look at it is they're looking at what we would consider phantom damages, right? It's not reality. It's not what the plaintiff is going to have to come out of pocket for. It's not what they're ever going to have to pay. And so what SB 68 has now done is it's now going to allow both sides to provide evidence to a jury that would fully disclose what the net is, right? So what the reimbursement was, what the out-of-pocket was, what was the reasonable value of medical necessary care, and disclose that in front of a jury. So it's not as much it's going to directly change what a jury will hear, but it's going to allow a jury to take into consideration the actual details, okay? Which is important. Same thing with letters of protection. The financial relationship between any contingency-based payment to a physician will be disclosed in that process. So this is really more about evidence reform, right, of what goes in front of a jury. I do believe this is going to have a meaningful impact, but one thing I will say is these large verdicts that you've seen, those 41 that we talked about a minute ago, if you look back at those cases, arguably about 70% of the value paid in those cases is related to non-economic damages, right, which will have no impact on the medical bills, right? But where this will have an impact is settlement values, right, on cases that do get settled, and otherwise kind of reasonably closing out a claim that's not catastrophic. All right, trial bifurcation. So I think this is probably, to me, one of the most interesting that we got passed, and I think one that will be the most beneficial. So here's what this means. Now in Georgia, a defendant can file a motion with the court and request trial bifurcation. That means that there's going to be a two-stage process to trial. The first stage of trial is going to be arguments solely related to liability in the case, the causation, right? So the attorneys will only be able to present evidence that's related to liability against the defendant. Experts will be presented to the jury only related to the liability in the case. The one thing that will not be discussed in that first stage of trial is damages. So there will be no evidence and no discussion around what the plaintiff lost, what the future expenses are for the plaintiff, future care, loss of income, et cetera. So why is that important? Well, when you start bringing damages into the case, which is the way they've been tried, right, where you're arguing damages and liability at the same time, there is an emotional response from the jury often, right? Because they say, oh, poor Miss So-and-so lost their income. They had this much in medical bills. They had X, Y, Z, and they start to have an emotional response to the plaintiff, and has an impact on the way in which they think about liability. I'll tell you, one of the things that scared me the most in the last 24 months, we had I had a client with a large verdict, and we interviewed the jury foreperson after the case because we felt like there is no way this is medical negligence. We felt really good about the case. Jury foreperson said to us, point blank, we don't think your doctor did anything wrong. We think it was the subsequent treating surgeon, but the subsequent treating surgeon was not a defendant in the case because they weren't named in the case because the statute had run by the time the plaintiff figured this out. But we felt so bad for the plaintiff that we're awarding, and it was millions of dollars against your doctor. And really, the takeaway for me was, okay, they emotionally responded to this. They didn't look at anything related to the medicine. He admitted basically that our doctor didn't do anything wrong, but we're just going to write a check because guess who's going to pay that pay that verdict? An insurance company. Well, what a lot of people don't realize is that that insurance company is only going to pay so much, unfortunately. And by the way, any amount that an insurance company pays, who pays for it ultimately? Bingo, everybody in this room. So that's what's scary to me. So my hope is in trial bifurcation that we will see a little bit more of a reasonable approach to juries looking at liability, right, and only determining that liability. So after that first stage, if they determine, okay, we're finding in favor of the defendant, or they apportion liability for more so to the plaintiff, right, and then the case is over, right, we move on, and we don't have to talk about the damages. So there's an efficiency piece to this in the courtroom. But then the other side is, if they do award against us, then it goes into a stage of discussion around damages, okay? What's interesting about that is, we haven't seen it yet, right? It's going to be interesting to see how the defense bar manages these when they go into trial bifurcation, because if they do find liability against us, right, it may be a great opportunity to say, okay, here are policy limits, right? Let's get this case over with. Let's not let the jury decide what the damages are. Now, in today's environment, that may be difficult to do because the plaintiff attorneys know they're in a good spot, especially if they already have liability in the case. But there's going to be a lot of changes in the way med-mal cases are defended in this. Last point on trial bifurcation, too. So a ton of states around the country have this statute, but what the statute generally requires is that there are punitive damages being considered in order for it to, and in fact, it will tricate into 3 stages. In Georgia, the way the new statute is written, it actually is much stronger than almost any state in the country that forcing the issue to allow trial bifurcation. In many states, the court has to determine whether they want to allow it. Well, there's only 2 exceptions in the state of Georgia now under the law where the court could push back and not allow it. So we will see where that goes. Anchoring is another one. So one of the things the plaintiff attorneys love to do is they'll go in front of a jury and they would say something like, you know, LeBron James makes $100 million a year, right? Don't you think poor Miss Susie's life is at least worth 10% of that? That would be the starting, that's where we're going to start the conversation. Well, what does that do? It sets a tone for a jury to start putting a number in their head, right? Or it costs, you know, $800 million to build a jet for the U.S. military, right? Don't we think this person's life is at least worth, you know, 0.5% of that, right? Those are tactics that plaintiff attorneys would try to use. So now in Georgia, we're changing the law and the rules on that where they can talk about numbers and they can tie in figures, but it has to be tied to evidence, right? There has to be some connection. We can't just bring up military jets and LeBron James contract, right? They've got to talk about something that is actually tied to evidence in the case. And when they go to close, and this happened a lot with plaintiff attorneys, depending on where they felt they were in the case, right, they're coming to that close in front of the jury and they're controlling their meter financially on how they think they've done in the case and how it's progressed. And they're going to control what their message is and what their ask is to the jury at that time. Well, what the law is now saying is, hey, listen, you can't basically bring something new in at the end, right, that hasn't been tied to the evidence that's been ongoing throughout the trial. So we think that these rules are right. It's interesting, the plaintiff's bar, this was one of the ones they pushed back on the most, which we found kind of interesting. That's how powerful they believe the tactic is. Double recovery attorney fees, these were 2 or 3 different statutes in Georgia that plaintiff attorneys were using to basically double collect on attorney's fees, and all of that is abolished now, which is good. Senate Bill 69, I'm not going to go into the details there, but Senate Bill 69 is basically about disclosure. It's about requiring disclosure of financial relationships as it relates to litigation funding or litigation financing. It's laws that are needed and something we're happy to see. Okay, so about the SB 68, because I get this question all the time, the truth and damages piece, and how a jury is going to hear the damages arguments, that is not going to go into effect but for cases that were filed or causes of action that were filed after April 25 when it was signed into law. Everything else is effective immediately, with the exception of the seatbelt gag rule and other pieces that were part of it. But for the med-mal side, that's where we are. Okay. Y'all bear with me as I go through this, because I got to give you a little bit of a history lesson along the way. So I want to explain common law versus statutory law, because it's going to be important in a new, kind of some updates and new news for you. So common law is developed through judicial decisions and precedents set for the court over time, right? It's the case law aspect, right? It's that law is developed as case law is developed and cases are tried and perfected and challenged. Statutory law is a legislative body creating a new law, a new statute, right? Some of this reform we just talked about. You know, in common law, you have judges interpreting and applying legal principles to then make decisions on specific cases, where in statutory law, you've got representatives or legislators who are saying this is the way we want the law to be. So in medical malpractice, it's tort law, it's rooted in common law. And that is, the law is set by the prior case events and decisions made in the court of law. However, what we see with caps on non-economic damages and other reforms are statutory law, right? It's legislators stepping in and creating new law in the state. So there are 2 different causes of action that you see with healthcare liability cases. The first is medical malpractice, and this is, again, common law, and it focuses on a healthcare provider's failure to meet the standard of care, right? And it's focused on the damage or harm, pain and suffering, future expenses, et cetera, of the patient, okay? And elements of these cases, which you've probably seen this before, but there had to be a duty of care owed to the provider, but owed by the provider, right? A physician-patient relationship. There had to be a breach of that duty, right? We had to make a mistake. And then there had to be a causation link to the breach. In other words, their harm that was caused to them had to be related to our mistake, okay? And then there had to be quantifiable damages, right? That they actually occurred or were hurt by what injury or what mistake we made. The other common cause of action in healthcare is wrongful death. And wrongful death causes of action, which they're often brought together, is where a patient has died and there may be a medical malpractice suit related to the underlying negligence of the argument of underlying negligence against the physician. But then there is a wrongful death cause of action brought for the benefit of the survivors, right? It's the family. So this claim or cause of action is focused on the survivors. So what's interesting about wrongful death is this was something from a cause of action standpoint that was created much later and has developed over time within the courts. And I'll explain why we're bringing this up here in a second. So medical malpractice damages, again, this is focused on pain and suffering, medical expenses, lost wages due to negligent care for the patient. And it includes both economic, so medical expenses, future care expenses, lost wages, et cetera, and non-economic damages, pain and suffering, loss of consortium, et cetera. Same thing on the wrongful death side, again, focused on the survivors, but it also includes economic damages, right? Loss of earnings, benefits, value that survivors would have received from the now party who is deceased, and non-economic damages, which is the intangible value of someone's life, which is hard to put a number on. So why are these causes of actions often brought in healthcare? Number one, they strengthen the argument for the plaintiff attorney, arguably, right? It's that we have the patient harmed, and they've had pain and suffering and damages, et cetera, but we also have all these damages of we've lost this patient and the value that they would bring to others. And then the real reason the plaintiff attorneys want to bring this is because it helps them to maximize damages, right? It creates two causes of action whereby the jury can award damages, and in some states, there are caps split for both causes of damages. And what the plaintiff attorney wants to do is give the jury the opportunity to award under both in order to maximize compensation. Okay, so many of you know about the Nestle case in the state of Georgia. So in 2005, it was Senate Bill 3. We had major reform package in the state. Okay, and it included a lot of different reforms that many of which are still in existence, some of which have been dismissed or found unconstitutional or changed by statute. But one of the things that the tort reform bill, or SB 3, included was a $350,000 cap on non-economic damages, and that was applicable in the statute to malpractice and wrongful death suits, okay? What the Supreme Court was evaluating when they evaluated the Nestle Hunt case. So the Nestle Hunt case was the case where the plaintiffs argued that the cap should not apply, right? And the case went all the way to the Georgia Supreme Court. So what were they evaluating as far as the Supreme Court justices? they basically said, you can't, it is against the Constitution to apply or reduce a jury award for non-economic damages for pain and suffering or loss of consortium in that case. The court concluded that the $350,000 cap violated the Constitution, and it was the constitutional right to trial by jury. Okay? And really what the court did is they evaluated, you see down here at the bottom, constitutional considerations. They were evaluating were the claim of liability existed in 1798, or when the Georgia Constitution was enacted. Did this claim of liability exist at that time? Because with the Constitution, we gave a juror the right to determine damages once a case was tried. So that's the way the Constitution was written. And did we have this cause of action of malpractice at the time in which the Constitution was adopted? And the answer to that, of course, is yes. And then right to trial by jury, did it attach to that type of claim? Was it appropriate to have a right to trial by jury? And the answer to that was yes. And then damages awarded by the jury, including non-economics, were those damages determined by juries, and was our intention for them to be awarded by juries in 1798? The answer to that is yes. So what the court found in this case was that the $350,000 cap was deemed unconstitutional, and they didn't allow for it to happen, but it was specific to malpractice, so medical malpractice from a cause of action standpoint. It did not take into consideration, because the patient in that case actually didn't die, it did not take into consideration wrongful death. Okay, so that's a key point. Okay, so we've got a development on this which may change how this cap applies long term. So the Turner case, this was one of the Macon hospitals, was sued along with several physicians related to a surgical complication, and there was a medical malpractice cause of action and a wrongful death cause of action brought against those parties by the patient's surviving daughter. There was a verdict against the parties, the defendants, and $7.2 million of non-economic damages were awarded specific to wrongful death. Again, separate cause of action for medical malpractice. The defense, interestingly, argued that the $350,000 cap, which was included in the statute developed from the 2005 tort reform, the $350,000 cap should apply to the damages that were, the non-economic damages that were awarded under the wrongful death cause of action. The trial court refused the $350,000 cap, and they cited that Nesselhunt said, no, the cap is unconstitutional, okay? Keep in mind that what Nesselhunt said is the cap is unconstitutional related to a medical negligence claim, right, or medical malpractice claim. The same thing, the case got appealed to Georgia Appeals Court, and the Appeals Court came back and said the same thing. The cap is not going to be applied. Well, Fence took this case to the Georgia Supreme Court, and in June of 25, the Georgia Supreme Court vacated the Court of Appeals decision and said, this needs to come back for further consideration. So, what did the court say? So, the court basically came back and said, this is the violating of the right to a jury trial and the caps applied only to common law medical malpractice claims. So in other words, back to our point earlier, the Nesselhunt case was only related to medical malpractice claims and not tied to wrongful death. And they deemed that the court, the lower courts, had automatically extended statutory, again, key point there, difference between common law and statutory, that the lower courts had automatically extended statutory wrongful death, automatically extended that the cap should not apply to the statutory wrongful death claims. And they said this case is remanded back to the lower courts, and they encouraged the lower courts to conduct further review from the constitutional evaluation. So they didn't, the Supreme Court did not come out and say, hey, we believe the cap should apply in wrongful death claims, but they said, we're going to force you, lower court, to evaluate this further. One key point in all of this is that, first of all, that was a big win, right? It was a big win that the Supreme Court didn't say, you know what, the cap that's been applied to malpractice claims is now also going to apply for wrongful death. So there's now an opening for wrongful death, which, by the way, wrongful death is a cause of action that is brought against obstetrics often, right? Especially if you have a deceased infant case or a maternal death, you would commonly have a wrongful death claim or cause of action. So the big news there is it opened the door. Furthermore, Justin Colvin came in and said in his writing, what do they call it, a concurrence with the position by the Supreme Court. He came out and pretty strongly said, you can see here, the constitutional right to a jury trial has traditionally been understood as a procedural right to have a jury, rather than a judge, decide questions of fact. And he said, Nesselhunt appears to be inconsistent with the traditional understanding of the right. So in other words, he's saying, I think we may have extended that right to jury trial a little too far. And he argued that it limits the legislature's ability to define legal principles applicable to cause of action. So he came out pretty strongly and said, hey, I agree that we're not going to apply these caps to wrongful death causes of action, but further, I'm not sure we got Nesselhunt right. And so that sends a message to the lower courts. It sends a message to all of us that the cap may be back in play as it relates to additional challenges. So this happened a week ago, okay? So the Clark case, another Bibb County state court case. So we have the position from the Georgia Supreme Court that they aren't going to allow the caps, or they're going to allow the cap to potentially apply for wrongful death. Well, in the Clark case, we have $22 million awarded to a plaintiff for the patient's life, the full value of the patient's life, wrongful death cause of action. The defense filed a motion to remit and amend the judgment and basically to reduce that judgment down to comply with the statutory cap of $350,000. So again, the defense had the benefit of seeing what this ruling was from the Georgia Supreme Court. The court, the state court, the lower court, granted the defense motion and applied the $350,000 cap. So now we've seen the Supreme Court say, you know, we're going to send this back to the lower courts from a ruling perspective. Now we've had a lower court rule in favor of applying the cap to wrongful death. So, is the cap back? The cap appears to be back for wrongful death, which is great. Can we get the cap back in a more broader sense? The hope is yes. So for all of you in this room, as you talk to legislators, as you talk to your peers, the one thing that's going to move the needle from a insurance cost perspective and a protecting you perspective is going to be a cap on non-economic damages. That's the bottom line. And if we can get that back over the hill, we will see more meaningful impact. And by the way, the bigger question is $350,000 the right number for a cap, right? I think there's many that would argue that no, it's not. And we may need to do what Virginia has done and other states have done where there's a much higher cap, but at least there's a cap at some level. right? So we don't have these runaway 50, 60, $70 million verdicts. All right, so in that Clark case, and I want to speak on this as far as what did they challenge. So they challenged, of course, that, hey, you can't do this, right? They basically said the right to trial by jury was something the Supreme Court decided on related to, again, malpractice cause of action in the Nestle Hunt case. And the court came back and said that wrongful death claims, again, different cause of action, fully post-date 1798. So in other words, we considered this to be statutory law, and because of that, they basically are saying the General Assembly, because it's statutory law, has the ability to create a different remedy for wrongful death, right? So they're separating the two causes of action and the fact that wrongful death is not considered common law. And then they said wrongful death claims are a distinct claim and kind of damages, which must be evaluated differently from other forms of non-economic damages, and a different analysis finds no violation of the right to trial by jury. So this is the big point on the argument of, okay, does the legislator have can legislation change what the law is, right? Do they have a right to say, hey, we don't think it's in public policy or the public's interest to have some unlimited liability by not having a cap in place? They talk a lot about, or they challenge separation of powers, and can you separate the application of wrongful death and malpractice? And the answer is clearly, they're saying the Georgia Supreme Court clearly allowed for that. And then equal protection, basically the argument back from the court is that the General Assembly can provide additional protection if they see fit for a remedy for wrongful death. Interestingly, this argument and the angle for challenging the cap for wrongful death came from a punitive damages argument, and that is punitive damages have a $250,000 cap in the state of Georgia, and that's really where the angle came from on this, which again, punitive damages weren't in existence back when the Constitution was enacted. Okay, so thanks for bearing through that with me. I'm not a constitutional attorney, and that is a lot of angles. But the important part is we're getting a cap back, hopefully. All right, so let's talk about insurance premiums and kind of where they're going. So this is the average base rate. So think of base rate as the cost of a piece of cheese pizza before they add the toppings, okay? Except in this case, toppings usually cost more. Discounts would come off of the base rates, okay? But what all the insurance companies do that are standard insurance companies and regulated by the state insurance department is they have rate filings in the state where they say, all right, this is the starting point of what we're going to charge for a physician in this territory with this limit, right? And they have to do this every year and justify, right, what that filing is and what rates they're charging. There's a consumer protection piece to this, right, where insurance companies don't need to be treating physicians differently. And they need to follow some set of rules as the way they underwrite and price risk. So what this is this is the average base rate between Curie, MagMutual, and the Doctors Company, which are the three largest market shareholders in Georgia. And this shows you kind of what the trend has been in GYN surgery. We've seen a pretty substantial and steady increase since 2017 in those rate filings. And frankly, I would argue right now, rate trend can vary between, call it 6% to 8% on the low end, to really 15, 20, 25% increases. If there's claims activity, we are seeing some wild responses from the insurance market right now. Obstetrics is a little bit worse. You can see a base rate of $111,000 right now in the state of Georgia. We have seen some escalation in some of the insurers' rates in obstetrics over the last 12 months, and we are seeing some pretty significant trends here. The reality is, look, if we look back 20 years ago, well, let's say 25 years ago, we're starting to creep in the direction of where we were going. Now, it's not as bad as what it was then, but we're starting to make some movement significantly back to really high premium numbers. Okay. So for those that don't know, we have a medical professional liability insurance program that is in partnership with the doctor's company with GOGS. If y'all haven't looked at it, I encourage you to. TDC has been a phenomenal partner, great company, and they are also financially contributing to GOGS as part of that relationship. So you support them, they support GOGS, which is great. And they are providing pretty substantial discounts for that program. All right, I've got like 4 minutes left. I'll open up for any questions.
Thank you. Ruth Klein from Athens, Georgia. At what point will Senate Bill 68 be taking effect? Is it cases that were already in the system had been filed, or is it going to apply to those cases, or is it only for cases that were served after a certain date?
So, good question. So, the only piece of SB 68 of material for medical malpractice actions that won't take effect for cases that are already in the queue is the phantom damages and the evidence reform piece. Everything else is in effect for any active litigation as of that April date of the law going into effect. And by the way, some of that may be challenged, so that's what common thought is right now. Anything else? You don't have to run, Dr. Bong.
Kathy Bong, Decatur, Georgia, retired. Do you think this tort reform can actually positively affect this rate trend?
Yeah. Yes. The problem is trying to tie the data to this, but 1,000% do I think this is, was this meaningful? It was meaningful. Now, back to the other point, though, of what would drive the most value is the cap. But to me, and I remember, which Kate was involved in these conversations, and I remember being in a meeting with this organization, and the Medical Association had put together a task force. In the conversation around what we got done with SB 68, the one thing I loved about the approach was this is common sense reform. Like, quite frankly, regardless of which side of the aisle you're on, right, or you're the plaintiff's bar, I mean, to argue some of these points, i.e. phantom damages, right, to me it's very hard to argue because it's common sense. Why wouldn't you want facts in front of the jury, right? And I think some of the things that were presented, and I think the governor, I want to give Governor Kemp a ton of credit in this. I mean, listen, he took this on and he said, I am getting this passed. And quite frankly, he was very frustrated with the business community on this conversation initially because he couldn't get a clear message from many of us of what do you want? And he got frustrated along the way. But back on point, the reality is I think it will have an impact. I think it was common sense reform. I think it pushes things in the right direction. I think with where we are politically in the state and kind of the fight that ensued, I don't think this fight is over. I think there is more to come. I think some of what's happening that I went through a minute ago, just what we can do from the legal perspective, right, and then what we may have to do from a legislative perspective, is interesting. But I think everybody's buckled into this for a long haul. And if you look back at '05 and when that got passed, I mean, it was a multi-year bloody fight. And this year was pretty bloody.
Bartley, Ben Cheek, I just wanted to thank you for your, just a great explanation and bringing this down where it's a difficult thing understanding. You did a great job. You know, we've had double-digit increases across the board, and kind of just looking through the tea leaves, hopefully everything you're saying today and pointing out, we're going to start to see that ease up some. As you said, tap the brake. But we've also, what you said is 2,000% correct. We need competition in the state without a doubt. And I guess, again, reading through your tea leaves, do you see some exit plans there, which would not be good? That's for sure. When St. Paul pulled out of here, there was a certain company that was the last one standing, right. And that was not a good time. And that is what prompted everywhere you're talking about through these really tough battles. So just any other little tea leaves, you kind of look at it, what do you think about that?
Yeah, Dr. Cheek,
thank you for this great talk.
Yeah, thank you. So the comments I would make is, first of all, when you look at the major malpractice insurers, okay, and those brand names of the doctors' companies, the Mag Mutuals, the Med Pros, the ProAssurance, Caveris, et cetera, when you talk about those name brands, those insurance companies aren't going anywhere from a financial perspective, okay? There is more capital in these insurance companies than there ever has been in the history of the business, okay? And part of that was from 2005 to 2015, the med-mal insurers never made more money than they did during those years, okay? Now, we've seen it, and it can go the other way in a hurry, right? And when you're starting to lose, $1.60 for every dollar you take in, right, the math doesn't work, okay? But one key point there is I don't see these insurers in a financial position where they're going to start exiting. Now, for any of the insurers that you're working with who might not be those name brands, you better be paying attention, right? Because we have already seen some insurers go belly up in Georgia that are risk retention groups, and we're going to see that continue over the next couple of years because what's happening is those smaller insurers, they are living and dying by their reinsurance agreements, right? They are really relying on a third-party insurance company to keep them alive. Well, if that third-party insurance company changes rates or says we're out, they're dead, okay? So be very cautious in those circumstances. And by the way, most often, those smaller insurance companies are the ones that are going to offer you the lowest rates. So just think and evaluate before you go by there. Okay. As far as, concerns around exits from Georgia, I think, if we look back to where we were when St. Paul pulled out of the market, I think we're in a really different time than with the insurance market as a whole. You had the mutual insurance companies, whether it be Mag Mutual, SVMIC in Tennessee, Curie, or what used to be Medical Mutual Insurance Company of North Carolina, right? There were a bunch of the bedpan mutuals that were all founded throughout the country back in the 70s and the 80s, right? What's different about today's mutual insurance company, I think, and one of the things that concerns me is all of those companies, you name all the mutuals for the most part, they now are all over the country. They're writing business in every state almost in the U.S. And so what worries me is even those mutuals, right, that have been dead set committed to their state, right, they got a big chunk of business that's not in their state anymore too, right? So we're what I'm trying to say is the markets change where everybody's playing in a bigger pond. And I think any dramatic shift of them exiting a state, there's going to be somebody that's going to pick up that opportunity because they got the capital to do it. I'm not worried about that. What I'm worried about is the pump the brakes event and them just saying, hey, listen, we'll keep the business we have, but we're not interested in being aggressive. And it really kind of becomes, an antitrust concern of just rising prices because there's only so many limited players that can manage the risk as a whole. All right. Hey, thank y'all so much. Appreciate it.